Good afternoon and welcome to the weekly business meeting of the South Carolina Public Service Commission. Today is Wednesday, April 16th, 2025. It is approximately 3:30 p.m. Before we begin, would you join me in a moment of silent reflection? Thank you very much. All commissioners are present in the hearing room. Mr. Scarborough, please, if you would, proceed.
Good afternoon, Chair Powers, Vice Chair Williams, and Commissioners. First order of business is to set the next regularly scheduled business meeting. Staff recommends that the next commission business meeting be rescheduled to Wednesday, April 30th, 2025 at 1 o'clock p.m.
Next business meeting will be Wednesday, April 30th at 1 o'clock p.m.
Thank you, sir. Today we have 8 items on the utilities agenda and 6 items on the transportation agenda. Item number 1 is in docket number 2025-72E. This is a request from Duke Energy Carolinas LLC and Duke Energy Progress LLC for approval of their minimum filing requirements templates.
As to item number 1 is presented by Mr. Scarborough, is there a motion?
Chair Powers.
Commissioner Caston.
Thank you. On July 13th, 2023, the Commission issued order number 2023-481 and docket number 2022-300-A, which approved amending the South Carolina Code of State Regulations, Chapter 103, Article 8, to implement new minimum filing requirements, MFRs, for general rate applications. These new filing schedules and templates will provide financial data, including rate base, net operating income, cost of capital, cost of service, rate design, and other information. Regulation 103-823A3 mandates that electrical utilities submit their proposed MFRs schedule templates for Commission approval. The regulation also requires the templates to be developed for a historical 12-month test period unless otherwise directed, and that data must be at the South Carolina jurisdictional level if applicable or available. Pursuant to the regulation, Duke companies filed these filing templates on February 20th, 2025. There have been no comments received from any interested stakeholders in this docket. I move that the Commission grant the request of Duke Energy Carolinas LLC and Duke Energy Progress LLC approving the company's minimum filing templates in compliance with Commission Regulation 103-823A3. I further move that the companies amend the file templates to include the company's names or other identifiers instead of the Commission's name and logo, and refile the updated templates with the Commission within 10 days of this order. I so move.
Motion has been made by Commissioner Caston. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 2 is in docket number 2024-336E. This item involves establishing a procedural schedule and addressing related matters in this docket.
As to item number 2, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you, sir. On March 14th, 2025, ORS, the Office of Regulatory Staff, recommended that the Commission calculate the 5-year revisit of the methodology for determining the value of energy from customer generators in this docket from the date of Commission Order number 2021-569, which was issued on August 19th, 2021. Using August 19th, 2021 as the date on which the 5-year period begins is consistent with the statute and will ensure the electrical utilities 2025 avoided cost proceedings are completed prior to a determination in this proceeding. Therefore, I move that the Clerk of the Commission schedule oral argument regarding the procedural schedule. Parties should be prepared to provide their respective positions on the following issues. Number 1, what is the appropriate scope of the proceeding, including whether the solar choice methodology should be evaluated in this proceeding given South Carolina Code annotated section 58-40-20E, which states the value of the energy produced by customer generators must be updated annually and the methodology revisited every 5 years. Number 2, whether a full evidentiary hearing should be required in this docket or whether the matter can be determined based on the filings. Number 3, any other issues that parties believe the commission should consider related to this particular matter. The commission will establish the procedural schedule based upon arguments made by the parties. I further move that Duke Energy Progress, LLC, and Duke Energy Carolinas, LLC, and Dominion Energy South Carolina, Incorporated be made parties of record in this proceeding. So moved.
Thank you, Commissioner Williams. The motion has been made by Commissioner Williams. Is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no. The ayes have it. The motion carries.
Item number 3 is in docket number ND-2021-5EG. This is a request from Piedmont Natural Gas Company Incorporated for confidential treatment of certain portions of the company's FERC Form 2 for the year ended December 31st, 2024.
As to item number 3, is there a motion?
Chair Powers,
Commissioner Thomas.
thank you. I move that the commission grant the request of Piedmont Natural Gas Company Incorporated, or Piedmont, for confidential treatment of certain portions of its annual report for the year ending December 31st, 2024. The report. Piedmont asserts the need to protect this information from public disclosure and that this information must be excluded from public disclosure under the Freedom of Information Act. South Carolina Code annotated sections 30-4-10 et sec. I further move the commission finds the confidential version of Piedmont's report contains information that is commercially sensitive and of a proprietary nature. Also, I move the commission find that this information is exempt from disclosure under the Freedom of Information Act and pursuant to Commission Regulation 103-804-S2. So moved.
Thank you, Commissioner Thomas. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it.
Item number 4 appears in docket number 2025-4G. This is a motion for admission pro hoc vici for Melinda L. McGrath, Esquire, filed on behalf of Piedmont Natural Gas Company Incorporated.
As to item number 4, is there a motion?
Chair Powers,
Commissioner Caston.
thank you. I move that the commission grant the motion of Piedmont Natural Gas Company Incorporated for pro hoc vici admission of attorney Melinda L. McGrath, Esquire, in docket number 2025-4-G.
Having heard the motion is made by Commissioner Caston, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no. All the ayes have it, and the motion carries.
Items numbered 5 and 6 are in docket number 2025-30E, and the commission may address them together. Item number 5 is a request from Ms. Carmen Morgan for an extension of time to retain legal counsel. And item number 6 is a motion to dismiss from Dominion Energy South Carolina Incorporated to dismiss the complaint filed by Ms. Morgan.
As to items number 5 and 6, I would like to pass the leadership on this to Vice Chair Williams and make a motion myself.
Thank you, Mr. Chair. Mr. Chair, you have the floor.
Thank you. I move the commission grant the request of pro se complainant Carmen Morgan for an extension of time to retain legal counsel pursuant to her March 24, 2025 filing. Complainant Morgan has until May 15, 2025 at 2 p.m. to retain legal counsel to appear for and represent her at the May 15, 2025 hearing at 2 p.m. Also move that the commission hold the motion to dismiss filed by Dominion on April 2nd, 2025 in abeyance until the hearing on May 15, 2025 at 2 p.m. The hearing that was reset for May 15, 2025 will convene as scheduled, and all parties, including Ms. Morgan, with or without an attorney, should be prepared to proceed with the hearing before the commission. I further move that any motions filed by the parties may be heard at the start of the May 15th, 2025 hearing at 2 p.m. So move.
Commissioners, hearing Commissioner Powers' motion, is there any discussion? Hearing none, we will vote, starting with Commissioner Powers,
I vote aye.
Commissioner Williams,
Aye.
Commissioner Caston,
Aye.
Commissioner Belzer,
Aye.
Commissioner Thomas.
Aye.
Vice Chair Williams votes aye. The ayes have it. The motion carries.
Item number 7 is in docket number 2024-144E. This is a request from Duke Energy Carolinas LLC and Duke Energy Progress LLC for reconsideration and clarification of Commission Order number 2025-188.
As to item number 7, do I hear a motion?
Mr. Chairman,
Commissioner Belzer.
thank you. I move that the Commission grant the request for reconsideration and clarification of Order Number 2025-188 filed by Duke Energy Progress LLC and Duke Energy Carolinas LLC as outlined herein. First, I move that the Commission grant reconsideration and explicitly approve the 2023 CPRE program subject to the terms of the settlement agreement as requested by the Duke Companies and as contemplated by the settlement agreement filed between the Duke Companies and the Office of Regulatory Staff. The only other party of record in the case, Carolina Clean Energy Business Association, was not a signatory but did not object to the settlement agreement. Additionally, I move that the Commission grant reconsideration to amend the language on page 26 of Order Number 2025-188 to reflect the language contained in paragraph 7H of the settlement agreement, which represents the intent of the parties and is supported by the evidence of record in this matter. Paragraph 7H of the settlement agreement states, the parties agree that in the event the Commission approves the 2023 CPRE program, such approval would be limited to the 2023 CPRE program as presented in this docket and shall not equate to the approval of and shall not be used as dispositive evidence of the following activities and consideration related to the execution of the 2023 CPRE program. 1. The reasonableness or prudence of any specific project activities related to the 2023 CPRE program. 2. Future recoverability of specific items of cost related to the 2023 CPRE program. 3. Pre-approval of any rate-making treatment related to the 2023 CPRE program. The paragraph reflects the testimony of record, which unequivocally demonstrated that the Duke Companies have a continuing responsibility to engage in prudent and reasonable decision-making in the execution of the resources procured through the 2023 CPRE program. Witness Smith testified that if the Commission approves the CPRE program, the day after the order comes out, we are still subject to acting prudently to managing the execution of the CPRE program, to make well-informed and reasoned decisions for customers from the day the order comes out on throughout the process as these selected projects advance. That's found at the transcript, page 36, lines 1 through 8, with similar statements at the transcript, page 45, lines 5 through 10, and transcript, page 69, lines 6 through 12. Given the testimony and evidence of record, there's ample support for granting the request for reconsideration to amend the language on page 26 of Order Number 25188 to reflect the actual language contained in paragraph 7H of the settlement agreement. While the language contained in the order is a paraphrase of the language from the settlement agreement, leaving the language as written, i.e. paraphrased, could be construed as an attempt to alter the settlement agreement and does not reflect the parties' agreement with respect to this case. I so move.
Thank you, Commissioner Belzer. Having heard the motion by Commissioner Belzer, is any further discussion?
Mr. Chair.
Vice Chair Williams.
Thank you, Mr. Chair. Commissioner Belzer, I fully support your motion to grant reconsideration and clarification of Order Number 2025-188. Primarily because your motion provides clarity to the Commission's decision in this matter that has been absent thus far. By way of background, the first vote on this matter occurred way back on February 19th, 2025, and resulted in a 3-3 split. Initially, a motion was made to approve the settlement as requested by the applicant and the Office of Regulatory Staff. Then a substitute motion was made to, and I quote, amplify, unquote, the language of the settlement, and it also was stated that the substitute motion had, I quote again, the same result, unquote, as the initial motion. The substitute motion failed, and then we went back to the initial motion, and the initial motion failed. Then on February 21st, 2025, the matter came before the commission again. A motion was made with various findings that were consistent with the settlement agreement, but for reasons that were not clear to me at the time, the motion did not directly grant or deny the request the applicants made in their application or the request made by the signatories to the settlement, and that is to approve the applicant's 2023 CPRE program as defined in their application and as presented by the parties to the settlement. During that proceeding, I even asked if the motion approved the applicant's, quote, 2023 CPRE program, unquote, as presented and defined by the applicant and requested by the signatories of the settlement agreement. That question went unanswered. This is where, in my opinion, the commission remixed version of the question the applicant asked in their application and the commission's modification efforts to the party settlement agreement first appeared. Ultimately, the motion passed unanimously, and I voted yes to approve the 2023 CPRE program and the settlement agreement. I realize now that that vote, even with a yes proceeding to approve the 2023 CPRE program and the settlement agreement, was not a vote for the motion after reading the majority opinion that was drafted based on that motion. It was not until April 10th, 2025, at the commission business meeting where it became clear to me that there had been an ongoing effort not to approve the parties' settlement agreement as filed and requested. The moment of clarity for me came when it was said from the dais, and I'm paraphrasing here, that there's not a law or regulation or procedure that requires the commission to approve the 2023 CPRE program. Now, fellow commissioners, please forgive my willingness to give the benefit of the doubt or naivete, but I sincerely believe that if there was a desire to modify or reject the settlement agreement, which is a serious matter, that desire would have been stated plainly. As I try to fill in the gaps on the logic behind not approving the settlement agreement as requested, I find the word choice and the silence in the motions that did not approve the settlement agreement interesting, because the record before us, as Commissioner Belzer has noted, is so clear and unambiguous that rejection and even modification is not supported by evidence of record. It seems to me, and again, this is me just trying to fill in the gaps, it seems to me that there was an effort to find a way not to approve the 2023 CPRE program. And considering how much time was spent on whether or not the 2023 CPRE program or the commission's approval thereof was a pre-approval, I understand that. But what I don't understand is, considering the fact that the applicant and the Office of Regulatory Staff filed a settlement agreement which was clear and unambiguous on its face, and the commission had an opportunity to review it. The settlement agreement clearly stated the evidence that would be presented, clearly stated who would testify, clearly stated what the applicant and the Office of Regulatory Staff agreed to and was not objected to by the party who did not sign. I don't understand the need for amplification. I don't understand the need for silence towards approving the program, and I don't understand how we got here. At this point, Commissioner Belzer, the motion you're making is for clarity, but it's really about how we do business here at the commission, because I'm indifferent if there's a belief that the 2023 CPRE program should be rejected, modified, or if the commission should remain silent on the issue. The substance of those arguments is not my concern. My concern is the procedure, because I'm not sure how we get anything other than approval of what was presented to us during that, what I would describe as a settlement conference. I'm not sure how we get anything other than an approval in full based on what was asked, considering that the only evidence we heard was evidence from the 3 witnesses who testified, their pre-filed testimony, and the settlement agreement. And so, Commissioner Belzer, your motion adds clarity to where there was none, and specifically, and I'm reading from the applicant's petition for reconsideration and clarification. This is page 3, the last paragraph. For the foregoing reasons, I quote, for the foregoing reasons, the companies respectfully request that the commission approve the company's 2023 CPRA program subject to the terms of the settlement agreement and reconsider the above referenced finding regarding future determinations of reasonableness or prudency to match the language of paragraph 7H of the settlement agreement, which speaks more directly to these matters. Commissioner Belzer, I think your motion provides an off-ramp to bring this matter to a close in a way that is supported by the evidence of record and remove any ambiguity or lack of clarity about how the commission wanted to rule in this case. Thank you for offering your motion.
Thank you, Vice Chair Williams. Is there any further discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Belzer,
I vote aye.
Commissioner Caston,
No.
Commissioner Thomas,
No.
Vice Chair Williams,
I vote aye.
Commissioner Carol Lee Williams,
No.
and I vote aye. The motion fails.
Chair Powers,
Commissioner Thomas,
I'd like to make a motion, please.
you have the floor.
Duke states that it seeks clarification as to whether the commission explicitly approved the 2023 CPRE procurement as an independent CPRE program as proposed, or whether the commission's order was limited to, quote, a review of the, end quote, 2023, quote, procurement as against the framework, end quote, established by the Commission in Order Number 2024-141. Further, Duke states that it, quote, is unclear as to the effect of the order since it did not explicitly and directly approve, end quote, what Duke labels as, quote, the 2023 CPRE program, not even as subject to the terms of the settlement, end quote. As Duke acknowledges in its motion, and as I believe the Commission clearly set forth in its order, the Commission approved the 2023 CPRE procurement as being consistent with the framework established for Duke's CPRE program, as established in Order Number 2024-141. Nevertheless, to remove any ambiguity and provide the requested clarification, I move that the Commission grant Duke's petition seeking reconsideration and clarification for the limited purpose of clarification, and specifically to clarify that the Commission approved the 2023 CPRE procurement as being consistent with the framework established for Duke's CPRE program, as provided in Order Number 2024-141, and not as an independent CPRE program. South Carolina Code Section 584120E2 does not contemplate Commission approval of each individual procurement. I further move that the Commission modify Order Number 2025-188 accordingly. Finally, I move that the Commission deny any relief requested in the petition not specifically granted herein. The Commission shall issue a full order. I so move.
Thank you, Commissioner Thomas. Having heard the motion by Commissioner Thomas, is any further discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Thomas.
Aye.
Vice Chair Williams,
Respectfully, no.
Commissioner Carol Lee Williams,
Aye.
Commissioner Belzer,
I vote no.
Commissioner Caston,
Aye.
And I vote no, the motion fails.
Item number 8 appears in docket number 2024-13A. This is a motion from Chem Nuclear Systems LLC to dispense with a live hearing and a request to allow Billy L. Carver to adopt the pre-file testimony of William Baroni.
As to item number 8, is there a motion?
Chair Powers.
Commissioner Caston.
Thank you. I move that the commission approve the applications for Class C certificates in item numbers A1 through A2 as identified by Mr. Scarborough. A directive order will be issued for each application in the respective docket.
Thank you, Commissioner Caston. Haven't heard the motion. I think, Commissioner Caston, you've gone to transportation. We still have item number 8. Commissioner Thomas.
Yes, sir, we do. I apologize.
All right.
Chair Powers.
Would you repeat the item number 8, Mr. Scarborough?
Yes, sir, I'd be glad to. Item number 8 is in docket number 2024-13A. This is a motion from Chem Nuclear Systems LLC to dispense with a live hearing and a request to allow Billy L. Carver to adopt the pre-file testimony of William Baroni.
Thank you. Do I hear a motion?
Chair Powers.
Commissioner Thomas.
On April 29th, 2024, Commission staff conducted a virtual status conference with the parties to discuss procedural matters, including the possibility that Chem Nuclear would file a motion for expedited review and to substitute direct testimony of a witness. No party presented an objection during the status conference. On April the 10th, 2025, Chem Nuclear filed a motion requesting the Commission use its discretionary authority to dispose of this proceeding without holding a formal hearing, and instead rule upon the verified docket filings. Subsequent to the motion, ORS filed a verification of its 2024 examination report. No party objects to the motion. Therefore, I move that the Commission grant the motion by Chem Nuclear Systems, LLC, for expedited review and to forego a hearing in this matter. I further move the Commission accept the verified supplemental direct testimony of Billy L. Carter. Finally, I move that Chem Nuclear be allowed to retain as recovery of its expenditures in operating the Barnwell Low-Level Radioactive Waste Storage Facility for the fiscal year ending June 30th, 2024, the following as reflected in Exhibit 1 of ORS's examination report. Number 1, $3,393,280 in fixed costs. 2, $815,008 in variable costs. 3, $286,558 in irregular costs. In connection with procedures performed for the fiscal year ending June 30th, 2024, ORS also examined transactions recorded by Chem Nuclear for the period beginning July 1st, 2024, extending through December 31st, 2024. Based on its examination, ORS recommended adjustments to Chem Nuclear's projected fixed and irregular cost for the fiscal year ending June 30th, 2025, as listed in Exhibit 2. These adjustments were discussed with and agreed to by members of Chem Nuclear's management. Based on ORS's examination and Chem Nuclear's projected variable rates, the Commission adopts ORS's adjustment to the rate per offload for silt trench operations. The company originally proposed $125,772 per offload. Based on ORS's review and through inquiry with the company, the amount per offload was updated to $72,606. So moved.
Commissioner Thomas, in your motion on number 3, as far as irregular cost, I think I heard you say $286,558. Would it not be $276,558?
Yes, sir. You are correct.
And can we make that correction?
Yes.
Chair
Thank you
Powers.
very much.
And I wanted to make sure I understood also. Was it April 9th or April 29th? I wasn't sure that I heard correctly at the beginning of your motion.
Should be April 9th.
Okay, thank you.
All right. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no. The ayes have it. The motion carries.
Mr. Chairman, I'd ask that, I'm hearing a phone ding. Could people silence their phones, please?
Mr. Chairman, that completes the utilities agenda before the commission. Moving on to the motor carrier agenda. In Part A, we have 2 applications for new Class C certificates that the commission may address together. Item A1 is in docket number 2025-115T, which is the application of K&M Transportation Services, LLC, for a Class C non-emergency certificate. Item A2 appears in docket number 2025-116T. This is the application of Grace Hens Universal Transportation, LLC, for a Class C non-emergency certificate.
As to items A1 and A2, do I hear a motion?
Now, Chair Powers, I'd like to make that motion.
Commissioner Caston.
Thank you. I move that the commission approve the applications for Class C certificates and item numbers A1 through A2 as identified by Mr. Scarborough. A directive order will be issued for each application in the respective docket. So moved.
Having heard the motion by Commissioner Caston, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
In Part B of the transportation agenda, there is one request to amend a certificate. Item B1 is in docket number 2022-199T, which is a request from JL Luxury Transportation, LLC, to amend Class C Charter Certificate number 9701 to reflect 14 passengers.
As to item B1, is there a motion?
Chair Powers.
Commissioner Thomas.
I move that the commission grant the request for JL Luxury Transportation, LLC, to amend the passenger restrictions on its Class C Charter Certificate number 9701 to reflect a maximum of 15 passengers, including the driver.
Thank you, Commissioner Thomas. Is there any further discussion? Hearing none, all those in favor signify by saying aye. Those opposed by no, the ayes have it. The motion carries.
In Part C of the transportation agenda, there are 3 requests for extensions of time. Item C1 is in docket number 2024-328T. This is a request from ZMZ Bless Life Services, LLC, for an 11-month extension of time to comply with commission rules and regulations.
As to item C1, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. On April 8th, 2025, ZMZ Blessed Life Services, LLC requests an extension of time for an additional 11 months to comply with Commission rules and regulations pursuant to paragraph 5 of Exhibit A to Order Number 2024-795, granting the authority to provide motor carrier services issued December 19th, 2024, and effective on January 18th, 2025, failure to complete the certification process by complying with the filing requirements within 90 days or requesting additional time to comply with the requirements of that order renders the order null and void. I move that the Commission grant the request of ZMZ Blessed Life Services, LLC until December 18th, 2025 to comply with Commission rules and regulations required to operate and use a Class C non-emergency certificate. Prior to the expiration of this extension period ending on December 18th, 2025, ZMZ Blessed Life Services, LLC must come into compliance with Commission rules and regulations or seek further extension or other relief from the Commission. If the motor carrier fails to come into compliance by December 18th, 2025, then ZMZ Blessed Life Services, LLC must file a new application with the Commission seeking approval of a Class C non-emergency certificate with the new application providing updated or current information. While the full length of the extension cannot be granted, ZMZ Blessed Life Services is provided an additional 8 months to come into compliance. Should the motor carrier need additional time, ZMZ Blessed Life Services LLC is not precluded from filing a new application with the commission when the motor carrier is ready to comply with the commission rules and regulations.
Thank you, Commissioner Williams. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
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 Those opposed by no, the ayes have it, the motion carries.
Item C2 appears in docket number 2025-53T. This is a request from Empower Health for a 12-month extension of time to comply with commission rules and regulations.
As to item C2, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. I move that the commission grant the request of Empower Health for an extension of time until March 5th, 2026 to comply with commission rules and regulations required to operate and use a Class C non-emergency certificate pursuant to paragraph 5 of Exhibit A to order number 2025-114 granting the authority to provide motor carrier services motor carrier services issued March 6, 2025, and effective on April 5th, 2025. Failure to complete the certification process by complying with the filing requirements within 90 days or requesting additional time to comply with the requirements of that order renders the order null and void. Prior to the expiration of this extension period ending on March 5th, 2026, Empower Health must come into compliance with Commission rules and regulations or seek further extension or other relief from the Commission. If the motor carrier fails to come into compliance by March 5th, 2026, then Empower Health must file a new application with the Commission seeking approval of a Class C non-emergency certificate and with the new application providing updated or current information. While the full 12 months cannot be granted, Empower Health is provided between 10 and 11 months to come into compliance. Should the motor carrier need additional time, Empower Health is not precluded from filing a new application with the Commission when the motor carrier is ready to comply with Commission rules and regulations.
Thank you, Commissioner Williams. Having heard the motion, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Item number C3 is in docket number 2024-346T. This is a request from Companion Express Transportation LLC for an additional 9-month extension of time to comply with Commission rules and regulations.
As to item C3, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. On April 9th, 2025, Companion Express Transportation LLC requested an extension of time for an additional 9 months to comply with Commission rules and regulations, which is in addition to the 3 months already provided by order number 2025-7. Pursuant to paragraph 5 of Exhibit A to order number 2025-7, granting the authority to provide motor carrier services issued January 9th, 2025, and effective on February 8th, 2025, failure to complete the certification process by complying with the filing requirements within 90 days or requesting additional time to comply with the requirements of that order renders the order null and void. I move the Commission grant the request of Companion Express Transportation LLC until January 8th, 2026 to comply with Commission rules and regulations required to operate and use a Class C non-emergency certificate. Prior to the expiration of this extension ending on January 8th, 2026, Companion Express Transportation LLC must come into compliance with Commission rules and regulations or seek further extension or other relief from the Commission. If the motor carrier fails to come into compliance by January 8th, 2026, then Companion Express Transportation LLC must file a new application with the Commission seeking approval of a Class C non-emergency certificate and with the new application providing updated or current information. Companion Express Transportation LLC is provided with approximately an additional 9 months of time to come into compliance. Should the motor carrier need additional time, Companion Express Transportation LLC is not precluded from filing a new application with the Commission when the motor carrier is ready to comply with Commission's rules and regulations.
Thank you, Commissioner Williams. Having heard the motion by Commissioner Williams, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Mr. Chairman and Commissioners, this concludes all business noticed before the commission today.
Thank you, Mr. Scarborough. We need to revisit that other. It's okay. And all those who joined us today, spring has finally sprung, I hope. Enjoy the weather and enjoy the rest of your week. We are adjourned.